So we have a very interesting decision that has come to us out of the great state of Massachusetts. Are we heading towards basically some kind of de facto national reciprocity or perhaps constitutional carry? That's kind of going to be what we're going to be discussing vis-a-vis the window of this particular case. Guys, let's get into it. So the topics that we're going to be discussing here really come to us in no small part whatsoever because of the Brune decision. That was the landmark June of 2022 U.S. Supreme Court decision that really has completely reshuffled the deck when it comes to the Second Amendment, and favorably so. What we're going to be talking about here today is whether concealed carry licensing regimes are going to collapse to constitutional carry, whether states will be compelled under the Brune decision to recognize other states' concealed carry licenses, regardless of what their Department of Justice or whoever are the folks that make their licensing recognition decisions want to do. It is important to note that this case is of zero precedential value in the strictest legal sense of the term. In other words, no other courts are going to be forced to do what this court has done. This is also not even of persuasive legal value, okay? But it may be of persuasive value in the cultural legal sense of the term. In other words, oftentimes judges, they're risk-adverse folks, not all the time, but oftentimes, there's just kind of a kinetic burst they have to use to become the first one to do something. So the fact that now a court has kind of broken this glass ceiling, hopefully we'll see others follow. If that happens, please contact me to let me know. The judge reaches some really interesting legal conclusions on, frankly, some interesting criteria that are both novel and intriguing that I think are, on balance, frankly, worth sharing and exploring, despite the highly limited precedential value to, frankly, anyone. That's one reason for me to take a look at this and kind of drag you along in this video. The other is that, candidly, my inbox has been flooded with people asking for a video on this particular case. So, citizens of the internet, my virtuous subscribers and viewers, I have listened. I hear you. Leaving comments does work, as does emailing the channel if you look up the email in the About section. So, that's it. Onwards. We're coming out of the Lowell District Court in the case of Commonwealth v. Donnell, which arises in the great state of Massachusetts. Here's kind of the very quick hit facts, which are going to be short. Mr. Donnell is from the Granite State. That's New Hampshire. Mr. Donnell decided to travel to, or more likely as I understand it, through Massachusetts with his firearm while presumably concealed carrying it or carrying it in some capacity or another. He was subsequently arrested and charged with concealed carry violation of Massachusetts law, and as I am going to go on to infer, this is not only a felony level offense in Massachusetts, but also carries, per the judge's written order, a mandatory minimum period of incarceration. Mr. Donnell brought three legal challenges. One, whether the Massachusetts statute is unconstitutional on its face. Two, whether it's unconstitutional as applied. And three, which we're not really going to get into all that much, but it's basically whether the statute's cruel and unusual, Eighth Amendment. We're going to be dealing with equal protections as we get into this. This is important. I want to teach you briefly how defendants in criminal courts often challenge the constitutionality of the law. Not many people know this. It is not a jury question for starters. Lawyers are generally prohibited from making such an argument that can be grouped under jury nullification, which this would be if you're claiming find the defendant not guilty because this law is unconstitutional. Juries can nullify a statute in a case, check your local listings, but a lawyer is prohibited from arguing for it. If you want to know more about jury nullification, let me know in the comments. I can perhaps visit that with its own video, but for now, once more, we press on. Instead, these attacks against the charges are done via a means called a motion. Motions are, statistically speaking, how most criminal cases, most cases in general, are actually fought. Not via juries. A trial, you see, is usually an argument about facts to a jury, though sometimes a judge. Both are called, for the purposes of a trial, the trier of fact. A motion, by contrast, is a legal attack on the case. Classic examples of motions that you've probably heard about are when defendants assert that their rights were somehow violated, perhaps due to an illegal stop, an illegal detainer, or an illegal search, being three common examples. These legal issues are determined by a judge, usually well in advance of a trial, and they help to set the evidentiary landscape and table for what a jury may someday hear should the case go to trial. To give you an idea, in my state of Wisconsin, only about, depending upon the county, the jurisdiction, about 2 to maybe 3% of cases in criminal court actually go to trial. A far higher percentage actually have motions. If you want to know more about motions, also let me know in the comment field below. Now, in this case, we are talking about how does a defendant attack a law for being unconstitutional. Generally, an unconstitutionality challenge by a defendant is an extraordinarily difficult claim to win in court. While the law does vary from state to state, in my home state of Wisconsin, the defense must notify the Attorney General's office of such a challenge to allow the AG's office to defend the statute if they choose. Next, the defense must show beyond a reasonable doubt that the statute is unconstitutional. Now, as any red-blooded defense attorney will tell you, that is a very high standard of proof, beyond a reasonable doubt. Really the highest we have in the American justice system. Though it's fun to watch prosecutors, speaking both as an ex-state prosecutor as well as a defense attorney, it's fun to watch prosecutors unaccustomed as they are to being the ones with the burden on their side to man the walls of arguing what a high burden of proof beyond a reasonable doubt is. Because keep in mind, in these hearings, they're saying, look, Judge, beyond a reasonable doubt, this is such a huge burden of proof that the defense has to overcome. I'm sure to a seasoned judge, this role reversal must be like watching a dog try to walk on its hind legs for both sides. If the defense prevails in showing that the statute or law is unconstitutional on its face, meaning it is going to always be unconstitutional regardless of the context of the case, then the judge can so order and dismiss that particular charge related to the statute. So in a single count case where the defendant's only accused of one crime, this would likely result in the dismissal of the entire case. If there's a multi-count charge involving different statutes, then it may result in only the dismissal of the particular count that the defense is challenging. This will not upend the written statute, and it will not be of precedential value if arising solely from a trial court judge. Remember, we don't make precedent from trial courts. We make precedent from higher courts, courts of review, courts of appeals, and so forth. If the judge so orders and sides with the defense, the prosecutor may decide to appeal the case and thereby risk making case law out of it by it going to an appellate court. Often prosecutors, just by way of background, a glimpse inside the trenches, prosecutors with an eye towards the big picture may demur and let the conviction go rather than risking the game, so to speak, especially if the fact pattern is sympathetic to the defense and the call's iffy. In other words, if, look, this is a sympathetic defendant and we've got sympathetic facts, this isn't like a bad person, first offense, and, it's a mitigated case, prosecutor may say, you know what, let's let this one go. I don't want to risk the game by perhaps losing this statute by going up to a precedent-setting court. Then again, if the fact pattern is awful, and the defendant is a frequent criminal justice system flyer with a long and checkered history, then perhaps it's worth the roll of the dice to the prosecution. That call is usually originating from within the Attorney General's office, not the local county prosecutor. In sum, a party challenging a law as unconstitutional on its face must show that the law cannot be constitutionally enforced under any circumstances. This contrasts with an unconstitutional as applied challenge, which is alleging that the statute is unconstitutional merely as it is applied in this particular case to this particular defendant because of reasons, whatever those may happen to be in that given case. For an as-applied challenge to succeed, the challenger must demonstrate that the challenger's constitutional rights were actually violated. For both types of challenges, courts generally start by presuming that the statute is constitutional, something that's of course captured and reflected in the no small part the burden of proof that the defense must overcome in order to win their case. Now, because I'm a big example person, a good example to help you understand this down the lens is, for instance, felon in possession of a firearm statute. An unconstitutional on its face challenge means that the defense would be claiming that this law is always invalid because it is unconstitutional to prohibit people from possessing a firearm on the basis of a felony conviction, period. Full stop. This would vary from an as-applied challenge where that might look something like the ban against felons possessing firearms ought to only apply to violent offenses, not non-violent offenses such as child support violations or theft crimes or something like that. On its face, always unconstitutional, as applied. Let's split some hairs and only in certain cases. I hope that helps. So fun digression that I hope you got something out of. Now back to Mr. Donnell in Massachusetts. If you got something out of that, by the way, because I don't know what you're going to like down the lens when I'm just kind of talking to a blank screen like this, please let me know by hitting that like button and of course leaving a comment below. I do read them. It does help me shape future videos. I never know if some amount of background or explanation is too much, too little, or just right. So thanks in advance for giving me some feedback. So the state, that's Massachusetts, the prosecution, basically makes the logical argument of, look, this is Massachusetts, not New Hampshire. We are not under any obligation to forfeit our Massachusetts laws by substituting those for New Hampshire just because someone happens to come from New Hampshire. Massachusetts is arguing basically that the full faith and credit clause of the Constitution does not apply here. What am I talking about? Okay, this one's much shorter, super short version. Full faith and credit clause is the requirement found at Article 4, Section 1 of the Constitution that state courts must respect the laws and judgments of courts from other states. What the Constitution is doing here is attempting to prevent conflict among states and ensure the dependability of judgments across the country, regardless of what state you are in. In support, Massachusetts cites a Massachusetts case that backs them up, and that stands for the principle that Massachusetts need not recognize other states' concealed carry licenses. Further, the prosecutors argue that the Brune court deliberately stated that the Supreme Court was not trying to interfere with the licensing regimes in different states, provided that they are shall issue and decided under objective criteria. Now, the judge came down on this like the hammer of Thor. First, the judge said at the time that Massachusetts courts made the decision that the prosecution's referencing, something called the Harris decision, that at the time carrying a firearm outside the home was regarded as a privilege. Now, it is been concretized as a right thanks to the U.S. Supreme Court in the Brune decision. That is a big difference, and it matters. Massachusetts is under no obligation to give the full faith and credit to a privilege, but a right, different story. Next is where the judge gets interesting, and this is kind of where it gets really interesting to me and maybe even a bit spicy. But before I do, if you like this video so far, please let me know. Click that like button. Of course, please consider subscribing to make sure you don't miss any of our future content. If you want to join the project and support what we're doing, after you hit subscribe, there's a join button with different memberships, which basically are extras, live streams, and so forth. I actually have one coming up very shortly. Also, of course, let me know in the comment field below and stick around to the very end for our ever popular quote of the day. First, the court observes the obvious. Carrying a firearm for self-defense is a protected Second Amendment activity. I'm going to skip even going through the analysis on this. I've done it in other videos. If you want, I'm probably going to do a whole just Brune test video. That way I can keep referring back to it. But for now, this is protected. Carrying a firearm as a Second Amendment activity. The question of equal protection arises. Again, this is where we get interesting. Equal protection is a claim that deals with people not being treated equally under the law. Here the issue is that Mr. Donnell is not from Massachusetts. If he wants to simply travel through Massachusetts, he must unload his firearms and secure them in a locked compartment under Massachusetts law. Further, the travel must be for a specific purpose, such as training or competition. The judge rules that this entirely misses the point of the Second Amendment, which is not about securing our rights to travel or train fundamentally, though of course that's certainly part of it. It is instead about our right to self-defense for personal protection. A locked and unloaded firearm is not going to accomplish that. You must be carrying a firearm for self-defense, not transporting a firearm for self-defense. This is a critical distinction that the court seizes upon. Next, the state argues that Mr. Donnell could get a license to carry in Massachusetts. Mr. Donnell would need to apply for what's called a non-resident license that is valid for 1 year as compared to a resident license which is valid for 5. However, the Second Amendment is no longer to be regarded as a privilege according to the judge under the law as it was in the pre-Brune decision. It is now a right to carry a firearm. We cannot treat people differently simply because they cross a line on a map. And here's where I love this. The judge observes what other core constitutional right ends because someone crossed a line on a map. Do you suddenly have a lesser right to religion, to speech, to be free from unreasonable searches and seizures or cruel and unusual punishment simply because you come from state A but are traveling through state B? Certainly not. Why does the Second Amendment get a second-class treatment, asked the court? Why does it indeed? Now again, extraordinarily limited in the precedential value, but what I like about this is the fact that the logic The logic to this travels. I'm going to try to stay on top of this to see whether or not other state-level courts across the country pick up on this theme, on this strand of logic and reasoning, because this really looks like it could be powerful in the travel. Time will tell. If you are one of these people who, God forbid, are facing one of these cases, or if you know someone who is, please have them reach out. I'd love to be able to speak to you on this. Now let's get to the quote of the day. This comes from St. Augustine. "The truth is like a lion. You don't need to defend it. Let it loose. It will defend itself." Thanks for sticking around. We'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.